Good afternoon, and thank you for joining us for today's webinar on the SEC's final private fund advisor rules. My name is Pat Palinko, and I'm a partner and co-head of the investment management practice at Seward & Kissel. Today, I'm joined by four of my fellow IM partners, Dan Bressler, Debbie Francis, Joe Morrissey, and Kevin Neubauer. As a preliminary matter, we note that the final rules were scaled back from the proposals, but we're only going to be focusing today on what made it to the final rules. So we're going to turn to the Preferential Treatment Rule, which is, I think, the rule that has gotten perhaps the most amount of attention to date. Joe, can you provide us with a high-level summary of this rule?
Absolutely. So the rule focuses on any type of special treatment that a manager provides to one or more investors or groups of investors in its private funds. And what the rule now requires is that all advisors are going to have to disclose in detail the specific terms of preferential treatment that they've granted to their investors in a given fund. So unlike before where we may have disclosed that we're allowed to do side letters, now, for example, you're disclosing the material content of essentially each and every side letter that you have out there, or other means of providing preferential treatment. The disclosures have to be provided prior to an investor's committing to an investment with respect to certain types of preferential treatment that are deemed material economic terms, particularly fees, liquidity rights are some of the key ones, co-investments being another. There is further disclosure of any other terms outside of that bucket of material economic terms that has to be provided after the fact. For closed-end funds, after the fact means after the final closing for that private equity or other closed-end fund. And then for open-end funds or hedge funds, the disclosure is provided after each subscription date where you've provided preferential treatment. There are also then annual disclosure requirements that pick up any sort of preferential treatment that was given to investors at other times. It's picked up each year. So in addition to the disclosure requirements, the rule will now actually prohibit two types of preferential terms. First, managers will not be able to grant investors preferential liquidity right if they reasonably expect that preferential liquidity right would have a material negative effect on other investors in that fund or similar pools of assets, which is a potentially broad category of vehicles that overlap with the fund in question. There's exceptions from the prohibition on granting preferential liquidity for things required by applicable law, such as bank holding company or similar outs. And then there is also the ability to offer preferential liquidity through multiple classes, for instance, or otherwise, as long as it's open to all investors without qualification. And in particular, without qualification means size qualifications, or you have to have invested in 3 out of my 5 products, or you have to be a certain investor type. It has to be open to all comers willing to accept the terms of that class. The second prohibition is on any preferential terms related to disclosure of portfolio holdings and exposure. So this is preferential transparency. And again, it's prohibited if the manager reasonably expects granting that transparency to an investor would have a material negative effect on other investors. Lastly, this is one area of the rule where the SEC did provide for what they call legacy treatment or grandfathering. It does not grandfather in existing funds, but what it does do is say that if a manager has funds that are up and running prior to the compliance date, and they have contractual arrangements with investors that are in writing, they don't have to revoke or upset those contractual arrangements. So essentially, if you have, for instance, a side letter that you gave preferential liquidity to an early investor years ago, that investor will be able to retain its liquidity rights. You won't have to make that material negative effect determination with respect to that, and it can continue. Similarly, if you had a class that provided greater liquidity, you could continue to provide that liquidity to those investors after the compliance date. Whether those investors, either under side letters or an existing class, can add to it probably will depend on whether there is a contractual capacity right. So that's the narrow sort of grandfathering that is out there on these rules.
So, Joe, I have some follow-up questions. First, what types of arrangements should a private fund advisor take into account when considering preferential liquidity and transparency issues?
Sure. So it applies broadly, and I focused in the intro on side letters and classes of interest, which are probably the most two common things that people think of. But it also applies to any formal or informal understandings, unwritten agreements, course of practice, really any manner in which a manager is providing preferential rights. So, for instance, if you're a manager that has a 90-day notice period on redemptions and you have an investor that always puts in the redemption before that deadline, but then you let them revoke it later on as the redemption date is approaching consistently, even if there's no agreement, you just accommodate that investor, it probably triggers the rule. So people have to think broadly about, any manner in which they're providing preferential treatment. Ad hoc waivers also appear to be covered. So by this I mean you didn't enter into an agreement with anyone, but someone misses the deadline for submitting a notice, or they're subject to a lockup, but they have some hardship case and they come to you and say, hey, can you help me out? A manager granting an accommodation in that circumstance needs to go through the analysis of the rule with respect to the material negative effect in a more probably formal and detailed way than they may have in the past.
And does the rule prohibit all preferential liquidity and preferential transparency arrangements?
No, and this is, I think, going to be one of the key things in coming to grips with this rule. The only thing that is prohibited is transparency or liquidity rights that the manager reasonably expects to have a material negative effect. And so it's only if you conclude that that's the case that you're prohibited from granting the right.
So it seems to me that the key term here, or one of the key terms, is material negative effect in interpreting this rule or applying this rule. How is that term defined for purposes of the preferential treatment rule?
Yeah, I think you could say it's a key undefined term because it's not defined. And frankly, other than giving sort of examples, it's one of those things where the SEC has said, well, material negative effect is a facts and circumstances determination, but don't worry about it. There's not going to be any hindsight bias or anything. It's a very different definition than what we're used to as investment management lawyers in thinking about materiality, because we think about materiality historically as a disclosure item. What would a reasonable investor consider significant in making their investment decisions or in monitoring their investments? And we had an obligation to disclose that. This, however, is sort of saying if you do something for one investor, what is the impact on the interest of other investors, and how to judge the magnitude of impact that is materially negative. There really isn't a specific definition. There isn't much guidance in the release, frankly, and there are not many analogous sort of uses of a term like that in the securities laws.
So turning to liquidity, what types of redemption terms must a manager look at to consider whether a given set of liquidity terms have a material negative effect?
Well, I think, you start with sort of the key sort of redemption terms of, what's the basic redemption cycle, monthly, quarterly, annually, for a given fund? What are the notice periods? What are the lockups if you're, again, talking about an open-ended fund? But it probably goes well beyond that too, into, are there gates, fund level gates, investor level gates? Are they applied consistently? Are there differences among classes or through side letters? Then there's just, things like payment timing. Some fund documents are relatively open-ended in terms of when you get paid after the redemption date. People will negotiate in side letters or otherwise that, you're gonna pay me 95% in 10 days, but the fund may have 30 days or an open-ended period. Are those preferential? The whole idea of payments being in cash or in kind, or being able to elect an in-kind payment rather than a cash payment. Suspensions, key persons, and other special redemption rights. All of those terms relate to redemptions and need to be looked at to see if they're preferential to one group or one investor, and then that material negative adverse effect analysis.
And so how would a private fund advisor conduct that review to determine whether these redemption parameters, are potentially or would have a potential material negative effect?
I think that's something that we're really going to have to work through. I think reading the language and reading the release, it certainly appears that from the SEC's perspective, you have to look at the different redemption parameters that an investor has, and the focus has to be on whether their exercise of that right impacts the other investors in a material negative way. But in assessing that, it does look like it's sort of a parameter by parameter thing, and it's not sort of maybe the MFN type thinking that we're used to as funds lawyers, where you might say, well, is the total package of redemption rights of investor A better than investor B? So, on that analysis, you might conclude that if someone agrees to a 3-year lockup and then goes to, monthly liquidity, when your standard class is 1-year lockup, quarterly liquidity, on an MFN basis, you might say, well, 3 years and then going to monthly is less favorable as a whole than the standard 1 and quarterly. But here, I think you very well may have to look and say, what would happen if the monthly redemption right kicks in after 3 years and they can redeem every month and all my other investors can redeem only quarterly? Is that a negative effect on other investors? So I think it's a slightly different analysis than we normally would think in an MFN or package concept.
So given that we don't have an express definition of material negative effect, what is the type of harm that the SEC is targeting through this rule?
Yeah, so I think that the from the examples or what they reference when they talk about the material negative effect and release, their main concern appears to be that if you have less liquid and more liquid assets in a portfolio, a monthly investor versus a quarterly investor, market moves, the monthly investor gets out, the manager is forced to redeem the most liquid securities to meet that redemption on relatively short notice. It shifts the liquidity of the portfolio for the remaining investors. Or the second one they seem to point to is that a investor redeems ahead of other investors, and there are other negative effects, such as the fund looks like it's going to be in liquidation, and those investors are sort of dodging the liquidation costs or other. But I think they were concerned about sort of missing something. So they're sort of saying, you think of what could be the negative effects of the redemption rights you're granting. But the portfolio weighting and selling the more liquid assets is the most concrete sort of concern they identified.
So do we think that there could be an expectation that the liquidity of a fund's portfolio could be a key consideration in the application of the rule?
Yeah, I would say that's one of the other clearer or more clear things that they identified, where they've said clearly the less liquid the portfolio, I think the more stringent you're going to have to be in sort of analyzing that material negative effect. So in theory, I suppose the more liquid your portfolio is, the more room you would seem to have different redemption rights that maybe are not materially negative to other investors.
Yeah, I guess a similar question is, what about private funds that have in-kind distribution capability or liquidating account mechanisms in their documents? What do we think the analysis would be there?
Yeah, I think it's certainly helpful, and I think a lot with this rule, and maybe we saw some of this with the marketing rule, is it really depends on how it's going to be enforced and how it's going to be applied in examination. Because, you know, if the key concern is, hey, you're going to overweight non-redeeming investors on less liquid or less favorable, or just change their exposures in a way because of preferential redemption rights, a liquidating account mechanism where you pay out from the liquid assets shortly after the redemption date, but take and ring fence then their pro rata interest in less liquid or problematic investments that maybe you can't sell because of, you know, securities law restrictions or what have you. If you did that and you do it consistently when appropriate, then presumably you've taken that sort of misweighting the portfolio off the table. I think that this is one of those situations where, though, taking that approach, you could see the SEC being stringent and sort of saying, well, hey, you know, you had cash coming into the fund and you didn't use the liquidating account. Prove to us that you wouldn't have held more cash under these market conditions if you didn't have those redemptions. So in other words, prove that those redemptions ahead of other investors didn't impact your portfolio management in a material negative way. And then, you know, it's sort of, how do you prove the counterfactual?
So switching now to the preferential transparency part of the rule, when a manager is considering preferential transparency, does the manager have to consider all types of transparency?
No, I think an important thing, and we've had some questions on this, it only relates to portfolio transparency, so portfolio positions and exposures. Things like, hey, tell me if you change your auditor, or tell me about staff changes, or other sort of periodic due diligence calls that don't touch on portfolio information, are not specifically prohibited by the rule.
So, as we mentioned a few minutes ago, the SEC has not specifically defined material negative effect. How should private fund managers consider that term in the context of transparency?
Yeah, so in transparency, they've focused on the fact that the portfolio information is an asset of the fund overall. And if it's disclosed to some investors, can they use that information to trade against the fund's positions, to front run the fund, to otherwise take advantage of the fund to the detriment of the other investors and enrich itself? And then it also appears to be that, you know, again, tying into sort of the liquidity issue, it gives investors a leg up to see if the fund is heading in the wrong direction, to get out ahead of other investors, especially if they have preferential liquidity, but even if they don't.
And so do you think that non-disclosure agreements or similar restrictions on using information could come into play here?
Again, it's going to depend on how stringent the SEC views it. But I think, you know, on the one hand, you could say, well, if the risk is using the information to the detriment of the fund, and I have strong NDA and other provisions that say it can only be used to evaluate their investment, I think there's maybe two issues with that, at least. One is you can see the SEC saying, well, an NDA is fine, but how would you ever know? How would you ever police that? How do you stop the bad actor? And maybe there's not a good answer to that. And then secondly, even if you have a strong NDA, you're not going to be able to say that you can't use that information to make your own redemption decisions. Now, maybe you could use time lags and other things, and then when the NAV and the other reports come out, somehow it's cleansed. But I think those are just two difficulties you might have in saying, hey, we have strong NDAs, there's no material negative effect.
Yeah, and finally, one final question on transparency. Do we think a manager will be able to provide information to an investor's third-party risk management firm?
At present, I would say yes. I mean, it seems to me that in a typical, if it's a typical sort of risk aggregator, you provide the data, they aggregate it with the client's other investments and just report that on a total aggregated basis. It shouldn't allow them to trade against the fund, and it shouldn't inform their redemption decisions in the same way direct information would. It's probably, in my mind, a lot easier to conclude with appropriate agreements that that's not a material negative effect on other investors.
So I know you touched on the legacy provisions in the summary, Joe, but how are the legacy provisions going to work in practice?
Yeah, so the key factors are that it has to be a fund that was commenced operations prior to the compliance date, and the preferential treatment in question has to be in writing, and it has to be a contractual right that complying with the rule would take away. So in other words, if you had a fund that's got, quarterly liquidity again, and you signed up someone with monthly liquidity years ago, you can't unilaterally go to that person and say, hey, I'm switching you to quarterly liquidity because they have a contractual right to monthly. So the SEC said, all right, we're not going to force you to renegotiate that agreement with your existing investors. If you have a partnership class that said, we'll accept up to $100 million in monthly at a different fee structure, and that class is now filled up, you don't have to kick all of those investors out of that class because, again, they have a contractual right to those terms. And so that's where I alluded to at the outset. Whether those investors, either under a side letter or a class, can put new money in probably depends on whether they have a contractual right to put the new money in at those other terms, which I think, especially with deals with seed investors, there's going to be a lot to look at there.
Right. So what should private fund advisors do now to prepare for this rule?
Yeah, I think that the key thing is going to be getting themselves organized. I think, managers are sort of all over the map in terms of, especially if they've been around for a while, what are their side letters out there? What are the different classes of interest? We've had clients that have changed their classes of interest numerous times over the year, but kind of grandfathered in investors, and the terms aren't even in the documents anymore that some of the old investors have. Investor relations people have sort of understandings with some of their clients that are maybe not reduced to writing. And until you know what you have out there, and then do the analysis of, hey, again, what are the potential negative effects that our inventory terms may have on other investors? That's just the starting point, is to just get yourself organized, get yourself cleaned up on what's out there, then go through the legacy analysis, and then decide, hey, what's going to make sense for our business going forward, given the constraints that the rule imposes.
Thanks, Joe.